Good afternoon, everyone, and welcome. I'm Judicial Watch President Tom Fitton, F as in Frank, I-T-T-O-N. Joining us on my left is Dr. Larry Kawa of Boca Raton, Florida. And also on my right is Paul Orphanedes, O-R-F-A-N-E-D-E-S, who's Judicial Watch's Director of Litigation. And Judicial Watch is pleased to announce today that it has filed a lawsuit on behalf of Dr. Larry Kawa of Kawa Orthodontics against the U.S. Department of Treasury, Secretary of Treasury Jack Lew, the Internal Revenue Service, and IRS Acting Director Daniel Werfel, challenging the Obama administration's decision to delay the enactment of the so-called employer mandate provision of the Affordable Health Care Act, also known as Obamacare. The lawsuit filed in the U.S. District Court for the Southern District of Florida, specifically in West Palm Beach, on behalf of the Boca Raton-based employer Kawa Orthodontics, LLP, argues that the delay of the employer mandate, quote, exceeded the Obama administration's statutory authority, is arbitrary, capricious, and contrary to law, and is otherwise unlawful. The employer mandate, which subjects certain large employers to tax penalties if they do not offer, quote, affordable minimum essential health insurance coverage to their employees, is one of the pillars of Obamacare. By law, the mandate was required to take effect January 1st, 2014, but on July 2nd, 2013, the Obama administration officially postponed the mandate, causing Dr. Kawa Orthodontics to lose the value of its substantial efforts to prepare for the controversial provision taking effect beginning next year. To quote from the lawsuit, which was filed this morning, Kawa Orthodontics expended substantial time and resources, including money spent on legal fees and other costs, in preparation for the employer mandate taking effect on January 1st, 2014. The company would not have expended its time and resources and incurred these anticipatory costs in 2013 if the mandate had not been scheduled to take effect until 2015. But instead would have spent its time, resources, and money on other priorities. Kawa Orthodontics is owned by, as I said, by Dr. Kawa, who's a longtime Florida resident and hardworking American community business leader. It employs more than 70 full-time employees in Florida. The complaint alleges that the decision to delay the employer mandate violates the Administrative Procedures Act, APA, which forbids agency action that exceeds an agency's statutory authority, is arbitrary, capricious, or an abuse of discretion, or otherwise not in accordance with the law. The complaint asks the court to enter a judgment declaring the delay to be unlawful and an injunction prohibiting the delay. We obviously object to the employer mandate and to the entire Obamacare law, but we understand that under the U.S. Constitution, the law can only be changed by legislation passed by Congress and signed by the President. President Obama would delay the damage of his health care scheme until after the 2014 congressional elections. But politics do not trump the Constitution or the rule of law. Now, allegedly, the employer mandate was supposed to cover at least 200,000 employers, as many as 1.2 million employers, depending on which numbers you use, and obviously millions of employees are affected by this. Senator Tom Harkin, one of the authors of the Obamacare law, when Obama first delayed the employer mandate, said, how can he do this? This is the law. It's in the law. We don't believe there's any discretion for the president to do this, and we're asking the courts to intervene here and to affirm the rule of law. As former Judge McConnell said in the Wall Street Journal, he compared the president's actions to those of King James II in England in days of old. So this is a serious matter for rule of law, and I'd like to turn it over to our client, Larry Kawa. As I said, he is an American success story. He built from nothing this tremendous practice in South Florida, one of the most successful local businesses in his community. He now has, as I said, 70 employees. He's doing this obviously because he was harmed. He's out money, he's out time, he's out resources, but obviously he has concerns as an American and requiring the president and the administration to adhere to the rule of law. I'll turn it over to Dr. Kawa.
Thank you, Tom.
Thank you. Larry?
First of all, thank you for being here today. I'm humbled by the opportunity to speak on behalf of the Constitution and the American people. I feel that polluted political tactics have marginalized the Constitution and squelched the frustrated voices of the American people for far too long. Power-hungry politicians have dipped their toes in the waters of tyranny and trained us to stand by along the sidelines and applaud them. And they've trumped the law, they've sidelined our core values, and then they high-five thinking that no one noticed. Well, I noticed. And I've had enough. He's crossed a red line. And on the other side of that red line is the most vigorous, aggressive, robust lawsuit that under federal jurisdiction I can bring with the help of my legal team, and it's coming. I am not here to dismantle the law. In fact, in contrast to that, I am here to help make sure that we enforce the existing laws. The only thing I hope for is that we could enlighten our president that he should do the same. A few weeks ago, the president waived the employer mandate, a very significant portion of the law, and I would suggest to you here today, he has no more power to do that than you or I. In fact, he has an affirmative duty to enforce the law, and we are here to make sure that he does that. He took an oath twice to preserve, protect, and defend the Constitution. It underscores the hypocrisy of what he is doing, that in fact he himself is the individual that we need to defend it from the most. He claims that he has legal reason by which he can waive the employer mandate, but in the same breath refuses to disclose it. He also claims that big business needs transition relief during these very challenging times. And then he also denies that same transition relief to the average working American that wipes the sweat from their brow with their calloused hands that they've used to lay the brick and mortar of the economic foundation of the United States. There could be nothing more emblematic of tax breaks to the wealthy on the backs of the middle class, and this is just more money for fat tax bureaucrats to put to their special interests in their individual programs. I suggest to you here today that he's in bed with big business. Congress has been given an exemption from something that is supposed to be good enough for us, but not good enough for them. Nancy Pelosi's entire district was exempt. If it is something that is so bad, I suggest, why don't we just exempt America? And exempt America the right way, through the permission of Congress. On July 17th, the U.S. House of Representatives passed a bill stating that they would agree to waive both the employer mandate and the individual mandate. They moved that bill over to the Senate. The president immediately intervened and stated that he would veto any action or attempt on the part of Congress to agree with him on either mandate. Now, why would a president do that? I ask you to ask yourselves. There's only one reason why. Because he's subversive. Because the Congressional Budget Office, according to the pay-go rule, has scored this as being a $10 billion buy-in. There have been non-enforcement periods before, but never nearly to this extent. He doesn't want to come up with $10 billion in entitlement cuts, so he is playing this political game and turning this into a political circus. Political circus has expanded its horizons, as you can see today. By the way, before I came here, my 6-year-old daughter said to me, you know, Daddy, maybe it's not that the president is not smart. Maybe he's just got bad luck when it comes to thinking. Let's help him think this through.
Thank you.
You're welcome. I have standing because I've made investments in both time and money as a law-abiding citizen and a local business owner to make sure that my business was in compliance with the law. And as soon as I did that, this president moved the goalposts, something he was not permitted by law to do. He's changed the law for political convenience. He's moved the goalposts. And I am tired of government picking winners and losers, victors and victims. And I suggest that it ends here today, and we're helped to end that corruption. I'm willing to abide by the law. I need that our government provide me with a law that is concrete, undisputed, and solid rather than fluid, because speaking as a local business owner, it's very challenging to build a business on a foundation which is fluid rather than solid. So let me be clear about my constitutional concerns. In order to waive the employer mandate, it requires the permission of Congress. Again, I am not here to dismantle the law. I am here to enforce the law and make sure that we do not allow an obstructionist president from preventing the same. He's ignored the Constitution. It's illegal, and I intend to stop him with the help of Judicial Watch and my legal team. The president has crossed the red line, but this time it's a real one. And I have had enough. Like many Americans who are sick and tired of being sick and tired, they have had enough. Actions have consequences, and members of government need to be privy to the fact and feel the fact that there are shockwaves when you violate the law, and you do it in the face of these consequences. This president has claimed in his own words that transparency and the rule of law will be the touchstones of his administration. I am here to help make sure that that occurs. I'm here to help make sure that he's fair and he plays by the rules and that he enforces the laws that he swore to enforce when he took his sacred oath. I refuse to stand idly by and watch this great nation fall prey to a predatory political process. So I suggest that we remain on the right side of the law, on the right side of history, and acknowledge that no one is above the law. And if there's one thing that you could take home with you here today from what I've suggested to you, is that like most Americans, I have had enough. I'm ready to take your questions.
Thank you. Paul, did you have anything to add?
Nope. Unless there's questions.
Let me, I need to announce some administrative detail.
I'll take a break.
Yeah. Just for those of you tracking at home, the lawsuit again was filed in West Palm Beach, Florida. The case number is 9:13-CV-80990. There's been no judge assigned to the case yet, and we are represented by local counsel in Florida. I want to be sure I have his name right. Chris Lunny of LUNNY of the Ready Law Firm, READE. And with that, as Larry suggested, we're available for questions now. Yes. Could you identify yourself, please?
I'm Bill Gibson of the Sun Sentinel.
Thank you.
I wanted to ask, I take it you're wanting to hasten the beginning of the employer mandate. Are you hoping that it turns out to be a success and will be one of the successes of Obamacare?
Is that from you or for Tom?
For you.
Penetrate.
Go ahead.
Like any other policy in our country, of course, I hope that we're successful at what we do and execute the will of the American people. It is not that I am here to hasten or slow down the implementation of the employer mandate. I'm here to suggest that it be done simply on time. Let the law stand or fall on its own merits.
You are in favor of Obamacare and the employer mandate in particular?
I am not in favor of Obamacare. However, I will tell you that it is the law, and I respect the law, and I hope we have a president that does the same.
When was the lawsuit actually filed?
10:30 this morning.
10:30 this morning.
And how much have you lost in legal fees?
Altogether, I've spent about $5,000 in legal fees, which to me, as a local business owner, seems like a lot of money. And if you're not sure if $5,000 is a lot of money, just ask Congress. That's what it took to buy them. That's what they get as a bonus for their tax-free, I should qualify bonus, that they can spend on the exchange at the taxpayer expense.
Just one last one. I think a lot of people would still be confused about if you're really opposed to Obamacare. Why do you want to hasten the beginning of this major provision?
That's an excellent question. While I'm opposed to Obamacare, my more overarching belief is confidence in the framework of the Constitution. To me, this is not about whether Obamacare is a good idea, a bad idea. Like I said, I'm certainly not here to dismantle it. In fact, just in contrast, I'm here to make sure that it's properly enforced, because that is what the Constitution recommends and insists upon.
If I could just add to that, if the law is to fail, it's going to fail now, not when it's politically convenient for the president. And to paraphrase General Grant in his first inaugural address, the best way to ensure the repeal of a bad law is to enforce it vigorously. And the president wants to avoid the consequences of his own law, and there are ways to do that legally, and that's through having Congress repeal it or modify it. But he's chosen not to do that and to act as a one-man Congress. And our Constitution doesn't allow that, and we expect and hope that the courts remind the president of his proper enumerated duties under the Constitution. It's otherworldly in many ways to be in a position to remind the president to enforce the law that is a touchstone of his presidency, but this is a creation of his own making, and one of the reasons people are confused about the law, if you're a supporter of Obamacare, is because of the arbitrary and capricious way in which it's being enforced and followed. So both supporters and defenders of the law might find something good in this lawsuit, but either way, we all need to agree that if the law is going to change, Congress needs to change it. The president can't do it on his own. Any other questions?
So you were hoping then that the law, by carrying it out next year, the law will fail?
Well, as conservatives, we oppose Obamacare, and we think that it's failing already, and it ought to fail as quickly as possible so the American people can move on from it. But to avoid the consequences of Obamacare by lawlessly delaying its implementation is not something we would agree to. It shows that Larry is principled. It shows that Judicial Watch is principled, and that they're going to seek to enforce a law that no one really likes. Unfortunately, Congress isn't willing to stand up and is supine in the face of the president's power grab here. But thankfully, our system allows individuals like Larry Kawa to step forward and stand in for the American people and the rule of law here. The idea that we have to argue with the Justice Department in the end about getting the president to follow a law that says it shall begin, at least this provision says it shall begin in January of 2014. I don't know what part of shall the lawyers don't understand at the Obama administration. Yes?
Jennifer Hickey from Newsmax. I just two questions for you. First, outside of the $5,000 cost that you incurred, what other impact has Obamacare had on your business? Have you had to change any strategy, business marketing? And secondly, have you continued to move forward with trying to implement it, or have you just stopped altogether?
It's a very good question. I consider myself to be a compassionate employer, and my staff is like my family. For 20 years, I've given top shelf insurance to my staff. I didn't need a law to tell me that I needed to do that. I will continue to do that in 2014, even though I am not required to. I hope that answers your question. Did you have any other questions?
In what way will you continue to do that in 2014?
I'm sorry, I didn't hear your question.
In what way will you continue to do that?
In the same way that I've done it for the last 20 years, is that I offer them Blue Cross PPO insurance, and they will be offered that same Blue Cross PPO insurance with no change in 2014.
And have you continued to move forward with steps, assuming that it's going to be implemented, or have you backed off on this?
I have moved forward with steps that are required, such as the exchange notice, which was required to be given out prior to today, which we did last Friday. I can't say that there's many other steps that really affect an employer in the absence of an employer mandate. So we've done everything that we're required to do.
So you gave that exchange notice to your somewhat 700 employees?
70 employees.
70, I'm sorry.
Yeah.
70, yes.
And I have a question for Mr. Fitton. Is this, in the broader context, is this the only lawsuit that Judicial Watch has filed related to health care? And if not, what are the other ones that you filed on behalf of others?
We have lawsuits under the Freedom of Information Act about its implementation, or frankly the shenanigans behind its implementation, and also its passage. Interestingly, I don't know what outstanding ones we have on Obamacare right now in the Freedom of Information Act, but I'm pretty much sure there's one or two pending. The government has notified us this morning that they're asking the federal courts to stay all the lawsuits that relate to our transparency efforts in federal court due to the shutdown.
That is Justice?
Justice filed that notice, is filing that notice this morning, or so we've been told. Yes, Roger?
Thank you.
Yeah. What's the distinction between the executive branch having created 20,000 plus more pages of regulation which have the effect of law, and then doing something like this, granting this waiver or this extension for the next few years?
Do you want to answer that, Paul?
Sure. That's precisely the distinction we're raising in our lawsuit. The government does have general rulemaking authority, but this is not a rulemaking. This is not even an interpretation of a statute. They're characterizing it as transitional relief. That's not something that is. First of all, this is different from any type of transitional relief that the government has used in the past. It's far more extensive in terms of its time, the dollar value of it, and the number of people and employers affected by it. So it's fundamentally different, but that's the legal question that we're going to be asking the court to decide, is does the government have authority to do this? And our answer is no.
Any other questions?
Who is your representative in Congress?
Ted Deutsch.
Speaking to the microphone.
Ted Deutsch.
Thank you.
Regarding your last point, you said, does the government have authority to do this? To do what precisely?
Well, to delay the employer mandate by at least a year. The statute's very clear. It says the months beginning after December 31st, 2013. That's January 1st. Everyone anticipated that it was January 1st until July 2nd.
And you're asking for an injunction
and a declaratory judgment declaring the delay to be unlawful under the Administrative Procedure Act.
It's estimated that it's at least $10 billion. So this is not an insignificant regulation that's being waived for a year. This is a massive program that was integral, so we were told, to Obamacare. And so the idea that the president can take it upon himself to unilaterally change a statutory deadline like this, which is so integral to the operations of the law that he proposed and is now implementing, is something that obviously is an error, and we're asking the court to correct that.
10 billion is the cost of implementation of the employer mandate?
10 billion is the expected revenue from employer penalties that would be levied under the Obama employer mandate.
In 2014, in about mid-July, CBO did a scoring of the costs of the changes, and it directly attributed $10 billion in employer penalties that would not be received in 2014, or because of the delay of the mandate in 2014.
Yeah, another thing to think about, not only are the employers being harmed in terms of the confusion, but employees are harmed as well. Their ability and their being able to figure out how to participate in the Obamacare exchanges is hurt by the delay of the requirement. The individual mandate was meant to work together with the employer mandate, not only financially in terms of government revenue and outlays, but because of the operations of Obamacare. That if your employer wasn't providing you insurance, you could go into the exchanges, and based on the nature of your employer's insurance or lack of it, you could get subsidies. Obviously, that's much more confusing as a result of the waiving of the employer mandate. So, just in terms of the operations of government and however monstrous this law, certainly it becomes even more damaging to the public because of this essential link being knocked out. We want it repealed, but the way to repeal it is not through a presidential act of the illicit nature that the president has done.
I have a question. Leah Duran with Breitbart. Are there copies of the complaint that we can?
Yes, the complaint is available as you, when I end the press conference, it will be made available to you. And as I said, it was filed around 10:30 this morning in Florida. Anything else? Okay, well, I appreciate you all coming out today, and we're around later in the afternoon if you have questions after you review the complaint. You can go and view the complaint, for those of you on the web, at judicialwatch.org, judicialwatch.org, and you can learn more about Larry's practice at braces1.com, braces1.com. So thank you very much.
And will you be posting the complaint at your website?
Yes, that will be made available on our website, but we have copies here for you now as well.